The more I study this stuff, the more I realise that there's kind of two quite discrete things happening here, and one around warranted access to material, as is reported in the TIA annual report, which is robust, and it's also a bit scrambled, as I think everybody has acknowledged and could do with streamlining and reform. But it's actually remarkably robust, and there's no serious suggestion that warranted access of information is being abused in any kind of systematic way in this country. It's reported, and we have a reasonably good idea. The breakdown is reasonably fine-grained enough so you can tell who's doing what and for what purpose. And then we've got this whole other area that's kind of ballooned in the last few years around warrantless regime for getting hold of telecommunications data or metadata. And we've had back and forth on this issue before. You do, also recognising that the government hasn't provided a response to the PJC inquiry of last year, so I don't know if I'd describe you as freelancing, but these are just the agency's views or the department's views. But you have indicated potential willingness to look at new oversight mechanisms for that warrantless regime. Do you want to just talk us through what your kind of high-level thinking is for that?
I might let Catherine say something in a moment, but I mean, in general terms, it's basically what I pointed out to Senator Seselja. We would be looking at some requirement to allow the current, or to require current watchdogs that are relevant to this area to look at whether those authorisations had been properly handled.
Okay.
At the moment, I think it's something they could do. They're not required to do. That would be, I think, I'm just looking at and you're familiar with the amount of material that we're talking about here, and the number of, I think that would be the most, let me say, effective and efficient way of doing it, and would give people comfort that the matter is being looked at by agencies who are given the job of looking at the content system in any event.
Okay. So then the two things that are potentially on the table without prejudice, one is restricting the range of agencies that might be able to access it at all. And the second is that the agencies or the accountability bodies that are watchdogging the warranted part of the surveillance regime could also be given carriage of the warrantless part.
Yes.
Yeah,
yes.
okay. What strikes you when you go through the annual report is the relatively constrained number of warrants that are applied for and active at any given time. It's in the low thousands, it's 3,000 or 4,000. And that number seems to be reasonably stable across annual reports over a period of years, as opposed to the sort of ballooning of the warrantless requests for telecommunications data, which have increased by 10 or 15% a year. So we're up to 319,000 for last year. And to me, what falls out of this whole process is the distinction that's drawn, and thanks again for providing us with your definitions of how you characterise telecommunications data, that it's the envelope, not the letter. And the conjecture that I would make is that if you stack up enough envelopes, if you have enough telecommunications data, you have content. You can build up very detailed maps of people's social networks, of their movements in space and time, and that is no less invasive than reading somebody's email, for which we have this quite rigorous warranted process. Without any of those safeguards, you can have extremely intimate information about networks of people or about individuals without crimes needing to be even alleged. So my question, I guess, is whether you think it's time to raise the bar, and if you've said in your submission you explicitly disagree that a warrant should apply for this data, but should there be some thresholds for the amount of metadata that could be collected on any individual, for example, before a judicial process at least needs to apply?
Well, you're right about the opportunity now in terms of the amount of traffic that's going around in terms of communications. I mean, clearly more and more people are doing more and more things online and with telecommunications. A couple of things about that. I mean, the authorisation process already restricts the types of activities that law enforcement agencies and intelligence agencies would engage into things where, if you use the common sense test, I mean, they're not going to pursue just ordinary individuals willy-nilly. They're actually going to go and look at things where they believe on reasonable grounds, and they have to apply tests of proportionality and privacy and stuff, that there is a point to this, from the point of view of crimes being committed or damage to Australia's national security, so that, and given the restriction of resources, etc., available to the law enforcement agencies and the intelligence agencies, nobody's going to actually go on a frolic. Occasionally, mistakes may be made, and if we had a ex post facto surveillance, look at what's been happening, those things can be corrected, and there are disincentives for people to do so. But I think there are resourcing disincentives for people to abuse that process as well. So I think that the balance is roughly right if you look at all the different aspects of this in context. I wouldn't be concerned. I don't think ordinary citizens should be concerned that people are actually going to misuse this power or process, and that there are sufficient checks and balance of a resourcing type, in terms of professional behaviour by law enforcement agencies.
Yeah, but a lot of this sounds low, though, like just take us on trust and take us on the fact that these agencies are stretched for resources and time, and they don't have time to just do dragnet surveillance. But that's not the point I'm making. The point I'm making is we have a robust, warranted system with judicial oversight and checks and balances for reading somebody's email, but not for tracking their every movement around the landscape and reading their entire social network. And my question to you is that why should that be subject to any less a degree of oversight and not simply taking it on trust as reading somebody's email? I would put to you that if in 1979 these categories of data had existed that allowed you to track people's movements everywhere they went and every contact they made with people, if you stack up enough envelopes, it would have been inside the warrant process. It's just that those categories of data simply didn't exist at the time.
Well, I'm not sure it's... Clearly there's a difference, and a number of authorities around the world have distinguished between what we loosely call metadata, we call telecommunications data, I think, and content. I mean, there is a very different qualitative difference in terms of intrusion.
Sorry, can I just draw you up there? Because I know the point you're trying to make. We've had this discussion before. How is it more intrusive to track a person's every movement around the landscape than reading their email? How is that any different degree of intrusion? It's extremely intrusive.
Well, you're interfering with their freedom of expression and what they actually say and what they're saying to other people. In one case, this is sort of going right into the centre of privacy, whereas finding out where they live,
where they are every minute of the day, where they're carrying a handset.
Yeah, but a lot of the information, the majority of the information that's actually obtained through looking at metadata is not traffic data. It's actually information about just who owns this number. I mean, I think it's somewhere, you'll correct me if I'm wrong, but about 80% of the authorisations that we're talking about were really for what I describe as sort of the identity bit, not the trafficking bit. And this is, on the other side of the coin, Senator, this is a critical tool for modern law enforcement to actually use to...
I understand that. I've read the submission. I understand how critical it is. I've got very severe misgivings about how easy it is to get hold of it.
The only thing I'd say about doing it through judicial warrant is, once again, the point I was making to Senator Seselja, that the practicality of this is also... it would make life very difficult if every time you did an authorisation you would need to go to a magistrate.
But doesn't it make life quite difficult to need to do that when you need to tap someone's phone? Like we've just gone through with your department,
Well, it is.
How arduous it is.
It is, and that is an imposition which, on balance, the various governments over a period of time have decided is appropriate, given the very intrusive nature of going in and listening to the content of somebody's actual conversations. The judgment has been, I think the balance is right, that in terms of metadata, and particularly that sort of requirement is not necessary. And that's certainly my view of the matter. But I mean, that's a personal view, Senator, and but it seems to have been the current policy in terms of the legislation, obviously.
It's a personal view, but it's very strongly reflected in your submission to the committee.
Yeah.
Yeah. I'll just bring you now, because I guess the issue of access to this material is then linked to data retention. How much of the material is being stored beyond billing purposes for everybody. With the current access to this telecommunications data, as you've defined it, is there any threshold according to who is going after? So, for example, you know, we've got, I think, an example in the last TIA Act annual report about a council going after somebody who was bitten by a dog. They were trying to find out whose dog it was, I think was the case study. Is there any threshold, like for an ordinary citizen who might find their metadata being requested by one or another agency, an ordinary citizen, a police officer, high court judge, a politician, is there any threshold at all or distinction between different people? Or is it just if the phone company's got it, it's up for grabs?
No, Chair. There's the Act treats all people equally. The threshold is whether they may have committed a criminal offence, a law that is punishable by a pecuniary penalty, and or the protection of public revenue. So any person who is alleged by someone who can access this information to fall within one of those categories can actually access it. There is no exception to a group of persons.
Okay. You don't need to have committed a criminal offence to find your metadata grabbed by somebody.
An allegation.
An allegation.
An allegation. And the point of collecting it is to find out if they have
a dog bite
cases.
Or dumping of rubbish. I mean, there's civil penalties for that stuff, but they're not crimes.
Well, it's pecuniary penalty, and so in the case of some councils, they can approach a provider if they are actually authorised to investigate certain matters where there are pecuniary penalties, yes.
So across the Commonwealth and the states and territories, how many agencies have people within them authorised to grab this data?
In any small council, etc., it's normally one person that can actually do it, and it's normally chief executive officers and that sort of thing. As far as the law enforcement agencies, the big end of town, the numbers are still relatively limited, and there's senior authorised officers, normally commissioners will authorise certain people. I can't give you those numbers, you'd have to actually ask.
Well, I'm not going to go and ask every single council.
No,
but
but the councils, generally, it's our understanding that it's only one person, that there will be a single point of access.
Yeah.
And part of that is also about to ensure the integrity of the system, that industry themselves have said, we don't want to deal with a scattergun approach. We want to ensure that whoever we're dealing with in a council or a law enforcement, that we have their signatures, we know they're on the books, and we know they're authorised to access this information. Okay. So it's very tightly constrained.
I might come back with some questions on notice, so we're just about out of time. My last question is around sharing of telecommunications of Australians with agencies overseas, and part of what's driven my interest in this inquiry are the revelations of Edward Snowden and other whistleblowers, or call them what you will. who have revealed in the United States very, very large scale accessing of material, content data and metadata. Is there anything, firstly, in the TIA Act that governs exchange of Australians' private material with other agencies, or do I need to look to other legislation to find that?
There is very limited in relation to mutual assistance, and as part of Australia acceding to the Council of Europe Convention on Cybercrime in the last couple of years, we have a provision now which allows, where other countries are subject to that convention, for a police-to-police to exchange telecommunications data when it falls within the thresholds of a serious criminal offence. But also there are very limited circumstances for mutual assistance, but Australia certainly cannot intercept on behalf of law enforcement under mutual assistance. It's only where the information may already exist that it can be provided over, under a mutual assistance process, which obviously goes through the relevant minister.
So that governs policing actions and law enforcement?
Yes.
What governs sharing between intelligence agencies?
I think those questions would be better placed with intelligence agency. They're subject to the Intelligence Services Act.
They still fall within your department, though, don't they?
The ISA Act is actually administered by the Department of Prime Minister and Cabinet. Yeah. Okay. So I'm certainly there is nothing that I'm aware of within the Telecommunications Interception and Access Act that deals with that issue. Yeah.
Okay. That's good to clarify. And maybe last one to you, Mr. Wilkins, before we wrap up. Trying to grapple with just how difficult it's going to be, whether the way your submission is drafted makes it look as though effectively what you're trying to do is give law enforcement agencies, or at least what you're referring to as the top end of town, access to any communication involving an Australian on any platform through any service or any kind of provider through some kind of process, warranted or otherwise. And I'm trying to establish if it's a cloud provider of a computer game, for example, that has no business footprint in Australia, that has a chat client within it. How do you get to them?
Currently, there are many what we call application service providers that sit outside Australia that provide services to Australians. And currently, assistance with those particular providers is done through mutual assistance channels or done through arrangements whereby they have a point of presence in Australia and under the TIA Act. What we think, and this is an international trend, is that these international service providers need to be responsible to domestic law enforcement and national security agencies. And so what we think is that it's important to consider how cloud providers, as you call them, provide services to Australian, are subject to Australian laws as any Australian provider is. So we just think that if they are providing services to Australians and it's a way for criminals to hide their activities, then they should not be given an opportunity not to assist Australian law enforcement.
Of course.
Can I just say, look, the question you raise is a big one. We probably can't do it in a few minutes, and it's engaging the attention of countries all over the world, and in terms of law enforcement agencies, intelligence agencies, but also privacy agencies as to how we square that circle. Clearly, borders are becoming less and less relevant in terms of national borders, and how we deal with that. We've got this system of mutual assistance, which is probably not. It's probably something else you should review next, actually. But it's certainly being strained to use that on a regular basis, and to some extent it means it's very difficult for law enforcement agencies to act on the basis of information in other jurisdictions unless there's a very smooth and streamlined arrangement with that country. So this is something that's exercising the deliberations and the thinking of certainly the quintet countries, but more widely it's something which my colleagues in other countries around the world, and I'm about to become president of the FATF. The FATF is very exercised about the use of or the exchange of information for legitimate purposes and under legal process, but something a bit more streamlined than the current mutual assistance system.
We will have to leave it there, as fascinating as that is. Could I just leave you with one on notice? And we, depending on the will of the committee, we may call you back later in our inquiry to take further questions. But if I could just draw your attention to a submission number 37 by Philip Dorling, who's got a fair bit of experience in these matters, who makes a brief point about the operation of warrantless requests for telecommunications data before, I think, the introduction of the Telecommunications Act in 1997. If you could just review his submission and make any comment that you think is relevant on that. So what I'm going to is...
Before 1997?
Yeah, before the Telecommunications Act 97 was introduced. Well, the question goes to at what point were you able to get hold of telecommunications data without a warrant? And there just seems to be real ambiguity about the history of how that's been done as these various categories of data sort of appeared out of nowhere. But we'll leave you be. Thank you very much for your evidence this morning and for offering your officers to the committee earlier.